Well, today's lesson is estate planning for the cognitively impaired. So that means that there's going to be a couple of topics we're going to hit on. First, we're going to discuss what legal capacity means in an estate planning context. We're also going to spend some time discussing the ethical duties of working with people who are cognitively impaired, as well as how to prepare an estate plan to withstand a legal challenge. Because there's really three things you have to take care of: making sure the client can actually sign their documents, how to deal with clients properly, and how to make sure that if it gets challenged, it's not going to be rejected just because you didn't dot your I's and cross your T's. So, that being said, the first thing we're going to discuss are the standards of capacity. And it's a very simple question. Does the person understand what they're doing at that moment? And now, there's a bit more details of that. They have to fully understand what their documents are, what their assets are. They have to understand that they're creating an estate plan, who the people are that they're leaving things to, what they're leaving to them, and how. But essentially, as long as they understand what they're doing, they have capacity. Now, one thing that's worth pointing out is capacity is moment-based. It's not based on diagnosis. So you have people who are sundowners. During the morning, they tend to be totally fine, and in the evening, they don't have a lot of capacity. Great example is I used to have a client years ago who, in the morning, you'd talk to him, you'd meet him, sharp as a whistle. A couple hours later, you'd meet him in the evening. He was very reckless. He wasn't really paying attention. You couldn't really get him to focus on what you were saying. So it's not based on a clinical diagnosis. It's based or what they're like at all times. Purely at the moment that they're dealing with you, are they aware of what they're doing? If someone is incapacitated, is catatonic 23 hours a day, and for 1 hour they have capacity, and for 1 hour they have clarity, that means they have legal capacity during that 1 hour. So don't focus on the medical diagnosis, focus on your interactions with them. Okay, it's about having a lucidity window. It's not about being permanently of perfect intelligence, of perfect clarity. To be honest, we all have moments. So I'm going to talk a little bit about the different types of capacity. So because in legal capacity, there's different eras. Testamentary capacity, it means you know what your assets are, you know who your beneficiaries are. That's different than contractual capacity, which, by the way, is also important because most estate plans are document-based. More importantly, when they sign their engagement letter, that's a contract. And contractual capacity means understanding the terms of what they're agreeing to, the consequences of their agreement, and the failure to adhere to that agreement. So for contractual capacity, they don't need to know who anyone is. They don't need to know what their assets are. They just need to know that they're signing a contract with you for whatever purpose. So the client comes in and says, I wanted to create an estate plan. They know what an estate plan is. They have contractual capacity. When you start asking them what their goals and wishes are, you have to make sure they have testamentary capacity, which is an awareness of their assets and beneficiaries. Now, there's also criminal capacity, which we're not going to go into because it's not part of today's conversation. That boils down to knowing what's right from wrong. By the way, these capacities, the rules are a little bit different in every state, so you want to be mindful of what the rules are in your state. But essentially, does your client understand what their assets are, who they're leaving it to, that they're leaving their assets to people? That's it. That is how you that is how detect capacity is that is what capacity is. Now, as an attorney, you have a bunch of ethical duties. On one hand, you have a dual responsibility. On one hand, you want to make sure that you carry out your client's wishes. You're not here to second guess them. You're not here to tell them what they should not or cannot do. Okay? Your job is, if a client says, I want to leave my money put everything I own in a trust for my cat, help them to create a trust for the cat. Doesn't matter that you disagree with what they're doing. What matters is what they want. At the same time, we also have responsibility to prevent undue influence, to avoid abuse. We certainly don't want to be helping people fleece their elderly or infirm relatives out of everything they have. So it's a bit of a balancing act to make sure that on one hand you're doing what the client wants you to do, on the other hand making sure that you're not they're not being pressured into something that they really don't want to do. So it's not about what they tell you, it's about what you uncover to be their true wishes. Simple question, someone says, I want to leave everything to my caretaker. Why? Is it because you really want to reward them for the help that they've been giving you over the years? Or is it because they've threatened you in some way? So don't just take for a given. Don't just assume that they'll do whatever they ask for. Verify. Now, if capacity is lacking, you've got to terminate the process. A couple of years ago, during COVID, we had a Zoom execution. Not the execution where you kill someone, but the execution where you're executing your documents. Husband and wife sit down at the camera, having a chat. Husband's talking, totally fine. Husband walks away, and I see the wife's mouth moving. So I think, okay, maybe the mute button's on. I tell her, press not everyone's good with technology. Please press the button, turn the sound back on. Everything seemed fine until the husband walked back in. Turned out the sound was fine. She just couldn't articulate anything. The mouth was moving, no sound were coming out of her. I said, I'm sorry, but we cannot act right now. We just have to cut it off at this point in time. Now, that same person may have capacity at a later date or at a different time, and that's totally fine. But at that moment in time, she did it. She could not tell me she could not answer questions, and therefore I had to cut her out. Okay? Now, it is an ethical balance. You want to be cautious, but you don't want to substitute your judgment for their judgment. Maybe you disagree with what they're doing, but it really is what they want. Help them out. Again, our job is not to push our goals onto people, our thoughts, our morality. Our goal is to do what's right for the client. So if the client comes in with something that you disagree with or that you think is suspicious, be cautious, but don't substitute your judgment for their judgment. That's not the purpose that's not why a client's coming to you. They're not coming to you to enact your estate plan or your idea of what their estate plan should be. They're coming to you so that you can help them prepare their estate plan to be the way they want it to be. Now, what you're going to find out is, we move very quickly, one of the biggest issues that you have on top of capacity is something called undue influence. Okay? Once you've established capacity, which is, does the person know what they're doing at that point in time, that's not the end of your inquiries. That's where you have a chat with them. First, you have to make sure they know what they're doing, they have capacity. That's a relatively easy hurdle when it comes to yes, some people clearly don't have capacity. They're catatonic, they're illogical, irrational, they just can't get a word, sorry, not irrational, you can't get a word out of them, they don't fully understand what's going on, then they don't have capacity. But if you do have capacity, they could still have undue influence. And I don't want to go so far as to say that all undue influence is elder abuse, but it is a sliding scale from being useful to someone exerting pressure on an elderly people. And it's not always conscious or intentional, but it could be that the caretaker is really driving things, is really pushing the client to do things they don't want to do. Or it could be so far as elder abuse. They're beating the client, they're threatening them, they're withholding food or medication if they don't do this. And you don't know if a client just walks in off the street, you don't necessarily know this, but you want to make sure that there's no undue influence for three reasons. First is you don't want to help do something that's wrong. I certainly don't want to help someone steal from someone else or take advantage of the infirm. Second, you also want to make sure that whatever plan you create will withstand a challenge. If it really is the client's goals, you want to make sure that's what you want to do. You want to make sure is adhered to. The last thing I want is for half my estate plans to end up being thrown out in courts 10 years later. And lastly, you might want to check your state ethical duties and requirements because I know that one of the rules says you cannot help commit an ongoing crime. straight up across the board, every state has a rule that says you cannot assist in a criminal act. And elder abuse can verge on the criminal. So that's probably probably not something you really have to be worried about, but at the same time, from a moral perspective, I don't want to do the right thing. So undue influence, there's certain common factors are an elderly person, a friend, relative, a stranger who has the opportunity and the motive. And one of the things you can see is what's called an unnatural outcome. If someone has 3 children, loves them all very well, but is leaving everything to one child, that's a bit of an unnatural outcome. If they have loving family and they're leaving everything to a stranger, that's an unnatural outcome. It's not necessarily wrong, but it is a common factor. So you want to make sure, it should raise a red flag. Speaking of other big red flags, is if someone is isolated. Okay, if someone's, say you have an elderly person who never leaves their apartment, they don't have a lot of friends and family, or they have very little contact with former friends and family. That's a red flag. It's not necessarily a problem, but it's certainly something you want to pay attention to. Another red flag is that the client has a high dependency on a particular person. And again, this is not necessarily an overt issue, but if an elderly person let's say an elderly person better yet, let's say someone with some mental conditions lives with a sibling and relies on a sibling to feed themselves, to clothe themselves. It's really hard for them to say no when that same sibling says, well, I really should get a bigger share of your assets. I'm doing all this work. And on one hand, it's true, they are doing all this work. Maybe they should be rewarded, but that might not be what the infirm individual wants. Another red flag is provisions that are out of character. That's a little easier to tell when you've known someone for years and years. Someone's been your client for 20 years and you've seen their estate plans change. You've done their estate plan and updated their estate plan a few years later, and suddenly they come back to you with something completely different. That's a red flag. If it's someone new off the street you've never met before, it's a lot harder to see if what they're asking you to do is out of character for what they want. So you really want to take your time, make sure that you check, and you want to ask questions. If you see red flags, first thing you're going to ask is, what has that beneficiary done for the client? Okay? What's the reason? Again, the biggest thing you can do is ask questions. So a client comes in and says, I want to leave everything to my nurse. Okay, well, what has she done for you? Obviously, she's a nurse, but if you're paying her, why do you need to leave everything else as well? Okay, what has that beneficiary done for you ask the client, what has that beneficiary done for you that you want to give them such a large reward? Okay, this isn't something that's very obvious, but you want to make sure you ask these questions. What has that beneficiary done that makes you want to give them that large portion? Another question you might want to ask is, why are you excluding your family? Why are you leaving nothing to your kids? And again, there might be really good answers to this, but you want to find out. If someone says, well, I haven't seen my son in 30 years, okay, you've got your answer. But if you see a tear well up in their eye then you might want to spend a little bit more time asking, why are you doing this? Is this really what you want to do? And again, it's a very fine line between asking, in a curious way, why are you doing this? In a helpful way, is there some reason you're doing this that is not apparent to me? As opposed to a nasty way where you say, well, why are you doing that? Why aren't you doing what every society expects? So at all times you want to be respectful, but you also want to make sure that you get to the bottom of it, who initiated the plan. One of the most common things that you'll see with undue influence is that the beneficiary was the one who initiated the plan. The caretaker child brings their elderly parents to change the will so that everything goes to that person. So if it's the caretaker, if it's the beneficiary who initiated the plan, that's a big red flag. Why are they pushing this poor person to leave them more money than they would have otherwise? And the problem with all of these things is it could be benign, but you really want to find out. You also want to ask, who selected the attorney? Did the client pick you? Again, not an issue if you've had this client for 20, 30 years, but if you've never met them before, did the client find you out of a phone book? Did the beneficiary select you? How did the beneficiary pick you? These are all questions you want to ask. Likely, you also want to make sure, is the beneficiary aware of the gift? Okay? Do they fully understand? It's one thing if a beneficiary brings an elderly relative along and has no idea that they're going to get more. If a client walks in and says, I'm leaving everything to my son who brought me here, he doesn't know that I'm not telling him. That's not undue influence. But if they say, yes, but if the beneficiary is aware, that's could be a red flag, and you want to ask, why, did you tell them? Did they pressure you? Don't ask straight up, did they pressure you, unless you're behind closed doors. And even then, it's might not be the easiest question to ask, but be a little diplomatic. The other thing you might have, and this is more if capacity is an issue than about undue influence. But if capacity is an issue, you want to ask your client to describe the assets. Do they understand the value of the account? Do they understand that the one account that they want to leave has $10 million? So their son has $10 million in it, and the account they want to leave their daughter has $3,000 in it. Okay? This is, if you're looking to find out if they understand what they're doing, ask about the values. If you want to verify that they know what they're talking about, ask them how did you acquire this asset? Oh, I want to leave my diamond ring to my granddaughter. Okay. Where'd you get the diamond ring? Oh, well, it's the one my husband gave me when he proposed. I want that to stay in the family. I want that to go to my granddaughter. Absolutely. My grandson and I were walking, 20 years ago when he was in college. We went to a museum together, and afterwards we were walking in a gallery, and he liked this piece of art, so I bought it, and now I want to give it to him. That's it. That makes sense. If they say, well, I don't know, I just have a pile of jewelry, then you might want to you might want to inquire a little bit more to make sure that they do have actual capacity. You might want to ask them to draw a map of land. A couple of years ago, I had a client who owned land in the middle of the forest, lived in the middle of nowhere, and she wanted to leave everything to this one hunter. Not a relative, not a friend. Well, first I asked why. Well, because every time he comes over, he helps me out. He never asks for a thing. He doesn't know I'm here. He doesn't know he's getting anything, but he helps out every time he's there. My family, I never see them. And I asked her, can you draw a picture of the land? So she drew a little map. By the way, this is very crude, would not win any prizes. She drew a map, roughly where the house was, roughly where the street was, drew where a creek was going through. She understood the land that she was giving to him. Okay. It wasn't just a matter of, well, I have land, I don't know. No, she drew a little map. There's no doubt in my mind she knew exactly what she had, why she wanted to give it to him, that she wanted to give it to him. Hardest part was actually finding his address, which he had somewhere. Likewise, if someone says, I want to leave some art to someone, ask for a description. Most people, they might not don't really have any valuable art, but if you get someone who owns one exceptionally valuable piece, ask for a description. Yes, I want to leave my Picasso. I know it has a lot of value. Absolutely. Oh, there's the painting in the living room that has the forest in it with a deer drawn on it. And I really want to leave that to this one person because I know they like the outdoors. Absolutely makes sense. Besides, if you're going to leave art to someone in a will, you want to leave enough description that you know what they're leaving anyway. All right? So you want to make sure that if you do see any red flags, you do ask to make sure that those red flags really are not as big a concern as they might appear. All right? Now, I got to give a word of caution that many of the factors that indicate undue influence could be the act of a dutiful child or faithful friend. Last year, I had some elderly folks who both had mobility issues. I don't think they could walk a block on their own. They could move with the walker, but not very far. Their son picked the attorney. The law firm picked the attorney. The son drove them there. That could have all the hallmarks of undue influence because they were living on, they couldn't really live on their without him taking them place to place. Well, they probably could order a taxi or an Uber, but they relied on him for transportation. He picked the attorney. He brought them there, but they left it. But after chatting with them, I knew it wasn't undue influence. They had very good reasons for what they were doing. He really was just being helpful. He didn't care about getting what he received. He didn't fully know what he was receiving either because we kept him outside. So even though that is the hallmarks even though those are factors indicating undue influence, he was just being a dutiful child. He was doing his best to help. Likewise, just because a client is giving all these red flags, they're isolating, they're giving everything to a caretaker. They're disinheriting children and families. They may have good reasons for that. Ask. I had a client who had 2 children, wanted to leave everything to the one that was being helpful. I asked him, he said, well, my other son didn't so much as send a card for my birthday, not a phone call, and hasn't for years. They never want anything to do with me, so therefore they can have nothing to do with my money. So again, when you see red flags, they're not necessarily a problem, but you want to talk a little bit. You want to make sure that whatever red flags there are, that it's okay. Now, one thing I like to tell people is if you see smoke, maybe there's a fire, maybe not. Even if there's a fire, it may be at a barbecue or a fire pit. It doesn't mean that there's a forest fire. But if you see smoke in the woods, you really should investigate, or at least call the fire department, have them investigate if you're not properly trained. But if you see red flags, you want to investigate that it's just that, yes, there is a red flag, but no, it's not a problem. The other thing you also have to be mindful of is the legal standards for undue influence vary from one state to another, and not only necessarily from one state to another, but maybe also to the relationship that people have. I know some states have essentially said that you can't have undue influence over a spouse. Okay? Even if a 93-year-old marries a 21-year-old caretaker and she pressures that 93-year-old into giving everything to just her, that might be totally legal in some states, and in other states, that's such a big red flag that would get thrown out, that it probably get thrown out without any evidence to the contrary. So make sure that wherever you are, you find out what the standards are in your state and whether the standards vary from one person to another. Does the same standards for a spouse, for a child, for a friend, for a caretaker? As an easy example, if a client leaves money to an attorney, to their drafting attorney, I know that in some states it's an automatic red flag. If I remember correctly, there's one, and I don't want anyone to quote me on this, I believe there's one state that automatically invalidates any bequest to the drafting attorney. Other states have no issue with it unless someone can mount a challenge for undue influence. So you really do want to check and make sure that whatever the rules are in your state, you know them, right? So next I'm going to talk about establishing autonomy. And this is making sure that the client is capable of acting on their own. So you want to see, and again, you don't need full autonomy to have capacity to have lack of undue influence, but the more autonomy you can establish, the better it is. If you're trying to protect against a future challenge to whatever you're doing, you want to see if you can write down in your notes how autonomous the client is. In their home, are they able to travel freely from their home, or are they kind of stuck without any help? Do they have physical activities that they can do? Someone who's bedridden and can never leave the house it's going to be much easier to challenge for undue influence than someone who's always out and about and doesn't rely on anyone. Likewise, are they loners who really have no one that they talk to, or even worse, that have been isolated from their friends? Or are they active in the community? Do they have friends and family come to visit all the time? Do they have hobbies where they go out and meet people or chat people? Do they go to the senior center? Do they go to the community center? The more you can establish that someone has autonomy, the better you can defend against a future challenge. Right? And again, the best way to prevent someone from challenging the estate plan you do is to keep track of all these things. You want to investigate, see what their social engagement is. You also want to see what their legal and financial autonomy is. If they did they pick the attorney? Do they have access to their assets? Do they have to go through someone every time? And it goes both ways. Does the client have access to their money? Can they write a check whenever they want, or is their caretaker withholding things? You'll get that sometimes, that an elderly person might live with a child who collects, and all their Social Security check comes in by check, and the child cashes the check, puts it in their own bank account, and the elderly individual can't access the account without going through their kids. So that could be a huge problem. Could also just be the child being helpful. The flip side is also true. Does the helper have access to the client's assets? Can they take it whenever they want? And are they acting responsibly in that case? And like with everything, it can go two ways. My grandmother, when she was getting up in age, decided she no longer needed to deal with these things. We were paying her bills for her every month. We had access to her bank account. By the way, there's some legal discussions they're way beyond this on accessing someone's bank account without permission. I'm not going to discuss that right now. That might be a different CLE, but basically, through the bank, my name was given to the bank as being able to access the account, made sure all the bills were paid every month. And let's be honest, most of it was automated, but still every once in a while I had to check to make sure that things were going smoothly the way they were. Right? So just because you see anything that looks funny doesn't mean it is, but you want to double check these things. If you want to stand a challenge, you want to verify all these things. You want to establish that someone has as much autonomy as possible when they created their estate plan. You also want to look to see it outside factors. You want to see if they're rejecting influence. If a client comes in and says, my son's pressuring me to put, my son asked if he could have the car because I've had some 1960s whatever classic, but he can't have it because I don't think it's right. Well, he's rejecting influence. Therefore, it's really hard to argue that he pushed pressure for other things. Someone comes in and says, I've been living with my daughter and she wants me to pay more, and she's asked me to pay off her mortgage. I refuse. Okay, she's rejecting influence. These are good things to know. From your perspective, these are good things because it establishes that the client is not being pressured. You also want to look at who other beneficiaries are. If someone's cutting out all their children and leaving a good chunk to their caretaker, but they're also leaving a lot of money to charity, to friends, that might not be under influence. They just decide to cut out their kids. So if someone leaves 100% of everything they own to their one caretaker, that's a pretty big red flag. If they leave 10% to their caretaker, leave 90% to their friends from the bridge club or to charity or the church, they're not being pressured quite the same way. And by the way, I do want to bring up, if they leave everything to church, you might want to double check a little bit, because and I shouldn't just say church, any religious organization or any charity for that matter, it could be all in the up and up, but if they're leaving 100%, could be that the clergy or the nonprofit's pressuring them. But multiple beneficiaries have nothing to do with each other is a good sign. If you don't mind me, I got to turn the light on for a sec, but it's on a timer here. Don't know why my office is on a timer, but whatever. Another thing that you might want to look for is, are they communicating transparently with people who are impacted? If someone's deciding to cut out one of their children and has told them multiple times about that, that it goes a long way to showing it wasn't undue influence. It was something they thought about for years. And also, someone who's been told far in advance that this is going to happen is less likely to challenge. More importantly, it also shows that it wasn't undue influence, it wasn't nefarious. Likewise, if someone's informing all their friends, if someone tells all their friends, my brother is such a jerk, I'm leaving him nothing, okay, it makes sense they're cutting him out. If someone says, I'm fairly well off, my sister's been struggling her whole life, my kids have all done well, so I want to leave more money to my sister. She's been telling all her friends, it's really hard to say that the sister pressured her into it. Another factor that might show that I don't want to say there was no undue influence, the wrong way to put it, but if someone has a diverse group of fiduciaries that have nothing to do with each other, that there's extra protection. In some states, an attorney can also be an accountant, can also be a financial advisor. I have ethical concerns about that, but if one firm is doing all the above for one client, that, maybe those fiduciaries are pushing a lot of pressure on them. Whereas if they're all unconnected, they kind of can work as a fail-safe against each other. And maybe it shows that they're not all the same. If someone says, I'm leaving everything to my niece, but I want my second cousin to be the executor, that could be an indication that maybe they're not being pressured. So having these diverse fiduciaries works as a kind of defense against claims of undue influence. But the single most important defense against undue influence, and it really is, are the attorney's notes. Okay? Ultimately, when capacity is being tested, they're going to ask, I really don't want to do this, but if you get called to the stand, you are the best defense. You get to explain how you determine, because as a lawyer, you know what the standards of capacity are, and you can protect against undue influence. So your detailed notes can show a clear story as to why there's no undue influence here, as to how you establish capacity. So someone comes in and says, if I have to go on the stand tomorrow and someone asks, how do you establish this person's capacity? I'm going to tell them about and by the way, if I know that either undue influence or capacity is going to come up later, I have much more detailed notes. Someone young, spring as a chicken, comes in and says, I want to leave everything to my kids. I don't need a lot of notes. Someone says, I really believe I'm going to get sued by my granddaughter. And I had this 2 years ago. A guy was about to be sued by his own granddaughter. And I'm not going to get into the whole family dynamics, but it was clear that she was going to allege incapacity. I have 5 pages of notes. Now, part of that is because he also was visually impaired. So I had notes of every meeting I had. And fortunately, he was very wealthy, so he could afford this, but I met with him 5 times for several hours each time. I kept detailed notes of how I read every page to him. Roughly with time, I spent 10 minutes here, 20 minutes there. Here's the questions that he had on this part. Here's the questions he had there. Here's the side story he told me about how he acquired that business and why he created that structure. So ultimately, I have 5 pages of notes I can go back to show that he had capacity to track the changes between the visits. Because I would come in and I said, my understanding is this. He goes, no, I don't. I want to change that. And here's my reasons why. So did I say 5 pages of notes or 5 visits? It doesn't matter. I practically wrote a book so I can show how I guarantee, I can tell you 100% certain this guy had capacity. I can show how there was no undue influence. There's notes on who selected the attorney, who was there. There was no beneficiary in that kind, but it might come up. Now, when it comes to verifying capacity, I've always hated it when an attorney says, do you know who's the president? Well, if you ask that today, client could have lost their mind 6 years ago, and they're still giving the right answer. I hate it when someone says, do you know what day it is? Sometimes I don't know what day it is. So you want to ask questions related to their family, to related to their assets. When you're establishing if they have capacity, can you tell me a little bit about yourself? Can you tell me a little bit about your assets? Can you tell me a little bit about your family and who your beneficiaries are and why? One of the things I really want to do every time is find out, is there anything you're not telling me? Is there a child you forgot to mention? I've had it a few times where someone says, what are your kids? I have Jane and Fred. Oh, yeah, and there's also Joe I had 10 years earlier, but I have no communication with them. That's an important piece of information. So I want to make sure that in the will we say, or trust or whatever document it is, you say, this is, he has 3 children. He is intentionally not leaving anything to, Joe? We are intentionally not leaving anything to Joe. I don't like leaving $1 because that $1 can be a headache to administer. Just straight up, I acknowledge Joe. I intentionally leave him nothing. Don't give a reason in the actual will itself. That's not the place for it. That giving a reason actually gives more of an opportunity to challenge it. Instead, put it in your notes as to why he's being left out, and make sure that you put in your notes why Joe's being left out. So that is completely set. The will is going to be treated differently from the attorney notes, which maybe nobody will ever see, but you might be called to testify as to why that happened. But at least in the will, keep it short and simple. I acknowledge Joe. I want to leave him nothing. Okay. Put in your notes who selected the attorney if it's appropriate. If there's concerns about undue influence, who selected the attorney? How did they come to you? Were they physically brought to you by a beneficiary? Oh, also, did the beneficiary select the attorney or did they select it? Asked, how did you hear about me? It's a benign question. How did you hear about me? How did you pick? Oh, my son pressured me, said to you, I have to use you. Why do you have to use me? I don't know. I just don't have much of a choice. Okay, there's a problem here. Well, or I had one last 2023 who said, well, my son does a lot of business with the firm you're at, and he's got all his business there, so I may as well use this attorney from that firm because I don't know any other attorneys. Okay, good for the notes. Likewise, you want to keep in your notes how involved was the beneficiary. Was the beneficiary in the room? Usually not a good idea, but there are exceptions. But if you know that there's a potential that this might be challenged, keep the beneficiary out of the room. Ideally, keep him out of the building. I did once have a client who brought his elderly parents. I said, thank you for bringing him here. Go across the street, have a cup of coffee. It's a little exaggeration, but I didn't even want the appearance of that he was doing anything more than being a chauffeur. Okay? But how involved was the beneficiary in picking the attorney, in bringing them there, in reviewing the estate plans? You have a client right now who is Korean. His English is fairly limited. His daughter's helping with everything, and he's leaving more to his daughter than his son. And that is a lot of red flags there. She has to translate everything for him. So I found a little workaround. I'm going to kick her out of the room. I'm going to chat with him. Well, no, actually, I was going to say I'm going to use Google Chat, but the reality is I have another attorney friend who's fluent in Korean and English. So she's going to assist just for determining that it really is his intent. I've had clients who are physically paralyzed. As someone could only communicate by blinking. So of course the helper is going to be involved in that case. The less involved they are, the better. But if they are involved, explain how, keep in your notes, how are they involved? Why are they involved this way? Because even the potential red flags, if you write a lot of details to how they're involved, it can still work to your benefit. Yes, of course the beneficiary brought them here because the client is disabled and can't move on their own. Of course a child came and acted as translator because they don't speak English. So here you're going to say that it's not undue influence, it's being a dutiful child. But at the same time, the one that I have that barely speaks English, I'm going to use, you can use translation software. Today, it's amazing. You can get an app, you can go on Google and translate everything you do quickly. You can have translation programs that'll actually talk. So the client I have who's Korean, I have a friend who's going to talk to him just to establish his no undue influence. But I'm doing an informal translation using Google Translate so they can understand what it is that I'm doing for them. They can understand the details of the documents that I wouldn't want to get lost in translation. I don't want to rely on the child to help with. So yes, the one child who's getting more is translating, is bringing them around and always brings them to the office. But there are times where I'm going to kick her out of the office, and there's times where I'm going to make sure that and communicate directly and circumvent the child just to verify that there's nothing nefarious going on. The other thing you want in your notes is you want to have explicit intent and understanding. This is especially when someone has some psychological conditions. Someone could be completely irrational, but if they can express clearly what their intent is and their understanding of their assets, it doesn't matter if they don't believe the government exists. It doesn't matter if they invented a new kind of math. This one I heard last week. Not direct. It was another attorney reached out to me for some guidance. So they had a client who said invented a new kind of math. I don't even know what that means. I've seen, I had clients who don't believe the government is real. I've had clients who think everyone's out to get them. But as long as they can document clear and explicit intent, make sure and document that they have a good understanding of what they're doing. There's even though they think that tree is a dog, they fully understand what they own and who they're leaving it to and how. I want to document. If I can document that, I'm happy to do so. Now, by the way, when you're dealing with undue influence or lack capacity, the three letters every lawyer should have memorized: CYA. Cover your assets at all times. Document everything clearly so that you can show, even though this person was detached from reality, they still were able to articulate to you what they were doing and why, or what they were doing, that they understood what they're doing. And if they're doing something weird, get them to give you an explanation. They don't need a good explanation they don't need an explanation you're going to like, but at least provide an explanation that you can understand, that you can put in your notes, so that if it's ever challenged, not only can you say, here's how I established capacity, here's how I can show there was no undue influence, here's how I could show that they fully understood what they're doing. Hopefully it never comes up, but also here's the reasons for it. It's not the most important thing. I once had a client who had the weirdest story. She is totally totally lucid. There was no question of capacity. Came on her own, had multiple businesses, and she decided that her daughter was wealthy and not a nice person. So she was cutting her daughter out. Her daughter had 3 children. 2 of them she was cutting out as well. One of them was getting a small pittance. Her 2 sons, one of them was getting essentially a life estate but no remainder. And the other son was getting everything. But when he passed away, so I said, great, I did everything accordingly. There really was nothing questionable about how she was doing it. And I said, can you tell me why? And she gave her reasons, so that if there's ever a challenge, if there's ever an issue, I can say, look, she had her reasons for doing this, and they were, I don't know if I'd agree with it, but she had her reasons. And by the way, the best part is when I said, when you do these crazy things, can you at least talk to your family and let them know, so feelings don't get hurt, so they know what's going to come. And she said, no, that's what I'm paying you for. So again, she had good reasons for not telling them, but I would rather she did tell them, because with advance notice, people are less likely to sue. They're less likely to challenge. And also it's easier to defend and say, yeah, she always did this, and you knew she was going to do it. If you had an issue, why didn't you solve this 20 years ago? But ultimately, people do what they want to do.
If you're in a jurisdiction that requires a verification code, please write the following code word down. FACE. F-A-C-E. FACE.
Now, there are a bunch of practical tools you can have to make sure that what you're doing is entirely on the up and up, or that everything is working the way it should. Apart from your detailed notes, and the notes really should be handwritten, customized to what it is. And make sure you keep your original handwritten notes if you can. I do typewritten notes as well because my handwriting is awful and I don't want to have to rely on it. But if I know there's going to be a challenge, I scan my notes in and keep them in, and then keep the originals in the file. But on top of that, you can have detailed intake forms to verify that to show that this is what the client intended from day one. Look, the intake form said I'm leaving Janie 80% and Timmy 20% and Fred nothing. And then I show, and look, my notes. I got that intake form on March 1st. We met March 10th, discussed it again, no problem. Provided the drafts on March 20th, reviewed everything, had no issues with it, came on the 30th for signing. I again mentioned this unusual disposition. She was totally fine with it. And if I get challenged in the future, look, starting with the intake form, here's what we had. Now, I'm going to assume most attorneys have some kind of intake form. So if capacity is an issue, you might want to have some questions related to that. But it's really keep the form if you think there's going to be a challenge later on. If you're concerned about capacity, you can do memory recall questions. I have a client right now who was in early stages of memory loss. I can't remember I believe it was dementia. Last year I had a client with early onset Alzheimer's. And so every time we'd meet, I'd ask questions not just about what we did, but do you remember what we discussed last time? Okay, well, if you don't remember, let's have a discussion about this. Does this seem right? Oh, no, it doesn't make sense I did that. All right, well, then maybe we should reevaluate. We want to make sure that there's consistency, that they remember what they said to you, that they remember what they did. Again, even if they don't remember, that doesn't mean it's a problem. But if you can document this, it's a plus. And speaking of potentially not a problem, potentially a problem, today you can make audio and video recordings. You can get a tape out, but most people these days, you grab this wonderful little tool that everyone has, and you can make a video recording right then and there. This cuts both ways. You can have a video recording that shows complete clarity, great evidence to show this person knew what they were doing, they understood what they were doing, how they did it, they had capacity, all the questions you want to ask. It can also flip the other way. If they appear nervous, hesitant, sweaty, if they keep changing their answer during the recording, hey, look, now you have evidence that maybe the person didn't have capacity. If there's multiple people in the room, you now have evidence there might be undue influence. So be very mindful of audio and video recordings. If they're not perfect, they could do more harm just as easily as they can do good. Okay? Think of it from a litigator's perspective. Every bit of hesitancy is an extra angle for them to attack. So I don't do video recordings as standard. I try and avoid them to the extent I can. I have done them a handful of times, but I really prefer not to, because bad lighting can make them look sweaty. Bad angles can make them look nervous. If you don't have a professional setup, the setup alone can cause problems. The sound cutting out at the wrong moment, the audio getting a bit garbled, focus changing at the wrong time. All these things can be used to attack you later. So be very careful before you move to audio or video recordings. Okay, that camera phone in your hand, great. You can document everything. Not everything means you should be documented. On top of that, you should really get permission. You really need informed consent before pushing someone into making recordings. Don't just bring it on them and say, based on this, I think I should record you right now. Hey, here, let me put this in your face. That's not right. Not ethically, not legally. It's not a good idea. So if you're going to do an audio video recording, set it up and talk to them ahead of time, set it up in advance, go to a professional videographer, make sure there's good lighting, good sound, and do one continuous take. If they need a stop, if they need a break, keep it rolling. The last thing you want is to be accused that that video is being edited. So pausing and then restarting is a bad idea. Pause and restart, even if it's not edited. What did you say when it was paused? So one continuous take. They need a glass of water? Fine. They need a 5-minute break? Fine. They want to talk about something else on a tangent for 10 minutes? Keep it rolling. Another practical tool you can have is having repeated visitations or calls. If over a period of about a month you've had 6 phone calls, well, maybe not a month. If over a period of a couple of months you've had multiple phone calls, multiple visits, and they're being consistent every time, and every time you talk to them, they tell you the same thing, you're probably doing, you can show a track record that everything's on the up and up. All right? So you want them to have, these are all tools in your toolbox that you can bring out if you need to. The most important thing is document, as to the extent you can, how you know that this person's capacity, how you know there's no undue influence. And, and again, it's, even though capacity is only one snapshot in time, arguing undue influence or trying to defend it, consistency over time matters. Right? If someone on Monday says, I want to give everything to my son, on Tuesday says everything to my daughter, Wednesday, nope, my kids get nothing, should all go to my brother. Thursday says, I don't like anyone, I just want to give it all to charity. I don't know about you, but I don't think that person has capacity. Look, you might look at it as a nice big paycheck because you just wrote 4 wills in 4 days. I personally would not do any of them. If they can't make up their mind, I don't want to document the wrong snapshot in time. So do be mindful of these things. Look, people do change their minds. I've had people say at the beginning of one meeting, here's what I want, and after thinking about it a bit more, they say, well, maybe not quite. It'll change a little bit. That happens. But think about it from a storyteller's perspective. Can you tell the story as to where they started, where they ended, and how they got there? A story's not going to jump left, jump right all the time. You're going to have a consistent story. He started by saying he wants to give nothing to his son because his dog's been helping him. Then he said, maybe my son should get 10%, 20%. I don't want to leave him with nothing. I should leave him with something because he is my flesh and blood. And a few days later, I said, well, 20% is a bit high. Maybe only 10% because it's just a token because I haven't seen him for a while, but he is getting something because he's genetically related. I can work with that. There you have a story as to why it changed. But if it's changing every day and if it's erratic is probably problematic. Ooh, there's a nice little alliteration. You can repeat after me 10 times. Anyway, so the key takeaways here are that if someone has Alzheimer's or other forms of diminished capacity, it doesn't mean they're automatically incapacitated. Okay? Just because someone's not 100% all the time does not mean that they can't sign their documents. Another thing to remember is that capacity is task specific. So you may have legal capacity you may have the capacity to sign a contract that doesn't have capacity to do an estate plan. You might have a capacity to do an estate plan. You might not have capacity to do a contract. An easy example of that, my daughter's asked me a couple of times what estate planning is, when she was little, because I've been doing this forever and a day. So I explained to her, if something happens to you, who's going to get your stuffed animals? She fully understands the question. She fully understands, I want you to have it. Not my mom, not mommy, just you can have my bear. And so she has the mental capacity to establish what a will is, but she doesn't have the legal capacity contracts. Now, she doesn't have the legal capacity to sign these documents at all, but she understands the question. So these things all come into play. Likewise, someone may not have criminal capacity because they don't understand that what they're doing is harmful, but they could still have capacity to understand that they want to leave all their stuff to their second cousin. Okay, so it's not a yes or no question. The other takeaway I want you to have is you should always honor your client's true intentions. The client comes in and asks for something, find out if that's their true intention, And if it, once you establish someone's capacity, honor their true intention. If they want to leave everything to save the whales, it all goes to save the whales, as long as save the whales didn't pressure them. Okay? And the last thing, the most important part is if you think that there's a good chance if there's a reasonable chance that the estate plan you're preparing is going to be challenged, you want to prepare a defensive file. Now, I'm not going to prepare a defensive file for every client, but if someone says, I'm cutting out this one child, I'm leaving, they're very difficult, they're always trying to steal from me. Actually, I had one, I signed 2 weeks ago. He's leaving his daughter nothing because she stole money from him, and she even sent him a police report. Or he even sent me a copy of the police report where she stole $200,000 from him. And he's leaving her nothing. She lives in a house that he owns. He's making sure it gets sold the day he passes away. Day of. But I know that when the time comes, she's going to challenge this. She will fight it tooth and nail. And so I have a defensive file to prepare for the fact that she's going to object to her father giving everything away. Now, the other thing to be very mindful of is different states have different rules. For example, Florida has a presumption of undue influence. If someone wants to challenge the will and they bring up undue influence, they don't have to prove that happened. The person presenting the will has to prove there was no undue influence. Okay, it's backward. It's guilty until proven innocent. I also operate in New York where you don't have that. It's a lot harder to challenge. So make sure that you know your state law and prepare accordingly. Now, if anyone ever wants to know what to look for, I practice in multiple states. The best case you can find that I've ever seen is called the Inree Carpenter from Florida from the 1970s. In Florida, there's a lot of articles that have been written by the bar about it, and it laid out clear and concise factors for determining undue influence. And so if you want to build a defensive file, read that case, or just read the synopsis of the case and say, here are the things that could cause undue influence. Let me protect against them. Now, there is no check the box list. There's no checklist for it. It's just whatever, but it's a good way to look at, and these are the things I have to be mindful of. And if I want to prepare a defensive file, these are the things I need to explain. If someone was helping, if you have red flags, which we discussed earlier, you want to be able to explain each of those red flags and why it wasn't a problem. Okay? Don't assume that, if you're building a defensive file, don't assume that it's a minor thing. It doesn't matter. Go through the list, go through every red flag and explain every single one of them. Even if it's negative, even if it shows that this is possible undue influence, you want to explain it anyway, but in a more positive light. So that when the time comes and if someone tries to challenge it and says, well, here was this one red flag, therefore it was undue influence, say, yes, we did see that red flag. We agree, here's why it looks troublesome, but here's why it isn't. Okay? And with that, I want to see if there's any questions, because I have exactly 1 more minute on the clock. And if there isn't, there is one last thing for me to go through, which is the capacity checklist that you can download as part of your materials. Again, you don't need this for every client, but if someone is incapacitated, if there is a possibility of someone not being incapacitated, not being it, or there might be an issue of undue influence, get this checklist and write your notes about it. Don't just check the boxes. Put these things in your notes. Okay? It doesn't have to be capacity and undue influence. It's not a check the box mentality. And capacity is either they have it or they don't, but undue influence is not a checkbox. Even someone who cannot state their full, as a straight example, can the client state their full name? Even if they can't, that doesn't mean they don't have capacity. Okay, not everyone knows their middle name. I have a cousin who barely knows her first name. No, she never used it. She always went by her middle name. And so right now, sure, she knows it, but when her mind starts to go, she might not remember her first name. Because she's always gone by her middle name. You never know what, I'm sure I can come up with other examples. It's been long enough. Is the client aware of the people in the room? That goes towards, do they have the mental capacity? But again, just because they say this person is a dog doesn't mean they don't have capacity doesn't mean they don't have testamentary capacity. Does the client understand the purpose of the meeting? If they don't understand the purpose of the meeting, end the meeting. If they sit there and go, oh, that's nice, and waffle off, they probably don't have capacity. Okay? The rest of these are fairly obvious. Can the client describe the nature and purpose of their legal decisions? Write these in your notes. How did they come to these? Why? Bit by bit. I'm not going to go through every last bit of it. And don't just check the box on each one. If you're worried about a challenge for undue influence or for capacity, give written answers in your notes. You can check the box for certain ones. Can the client state your name? Check, move on. Is the client aware of the people in the room? Let them describe the people in the room. I once had someone where capacity was a question. So that who's the person next to you? Oh, that's my daughter. Person on the other side of you, and I knew the answer beforehand, is the person on your other side also your daughter? She goes, no, that's my nurse. Okay. You know who the people in the room are. You know that there's people in the room. You know who they are. You know why they're there. Do you understand? Can you explain the consequences of your decisions? You don't have to ask that of everyone. But if you do have to ask that question, you don't want to check the box answer. You want to give a full written description. Even if it's just a half a line, you want some kind of writing to explain why, that they do understand the consequence of their decision, because that's not the kind of question that you would even consider if it wasn't going to be a problem later down the line. And the client remember recent discussions. Great if they can. If they can't, explain why the fact they can't remember is a problem. All right. Okay. So someone asked a question, are attorneys reluctant to take cases to prove undue influence? I can't answer that. There's enough attorneys out there that you're going to find someone who will. I know that there's attorneys who don't want to take this on at all. They don't want the headache. There are other attorneys who will take any job for a paycheck and everything in between. There are 1.3 million attorneys in the U.S. last time I checked. So whatever you're going to ask, you're always going to find someone who will take the case. All right. Now, going off to the checklist, again, this checklist, it's useful. Look it over. It's not it's not a bulletproof vest. It's not a silver bullet. Use your own judgment. And at this point, I'll say if anyone has any questions, you can always reach out to me. My name is Stefan Dunkelgrun. You can reach me at stefan@paramisep.com. So just to repeat this, S as in Sam, T as in Theodore, E as in Edward, F as in Frank, A as in Anthony, N as in Nancy, at Paramus, PARAMUSEP.com. And I'm happy to answer any questions you might have. And with that, I'm going to end this.